Assalamualaikum and hi, I am Nur Akilah Aidani binti Razwan and my matrix number is 055494. Today, I will be presenting the relation between Islamic jurisprudence and an act that me and my group mates have drafted before, which is titled Protection From Harassment Act 2022. Let's start with 5 objectives of Islamic law. First, we are commanded to protect our religion or al-din. This can be done through various acts of ibadah such as performing prayers, zakat, haji and fasting. Next, we are commanded to protect our life. Life is essential and valuable and it must be protected under any circumstances. There is no difference in value of a rich person's life or a poor one, leader or subordinates. All life are equally important and valuable. Next, Islam emphasizes on protecting dignity. It includes individual rights to privacy and not exposing or accusing others of misbehavior. We also have protection of intellect. Because akal is what differentiates humans from animals, we should use our intellect to give benefits to mankind and refrain from using akal to commit any evil deeds or anything that would harm others. Lastly, we also have protection of property. Property is a necessity for humans to survive. Muslim is allowed to own property as long as we obtain it within legal means. Islam prohibits the act of acquiring properties illegally, such as stealing, robbing, or taking riba. Al-Tabrizi has reported that it is not for a believer to indulge in insults, sarcasm, or cursing. This is a saying from the Prophet itself. Next, we also have is supported by Surah Al-Hujurat, verse 11, nor defame, nor be sarcastic to each other, nor call each other by offensive nicknames. Ill-seeming is a name connoting wickedness after he has believed, and those who do not desist are indeed doing wrong. We have incorporated the principles of Islamic jurisprudence in our act that we have drafted before. For example, in Section 3, Clause 1, we stated that an individual or entity must not, with intent to cause harassment, alarm, or distress to the victim by means of use any threatening, abusing, or insulting words. And as you can see, provisions B and C. And lastly, and as a result, to cause of the victim harassment, alarm, or distress. We also have incorporated Islamic principles in Section 5, Clause 1, which is to prevent others from inflicting fear or do any provocation or even facilitation of violence upon others, which means in line with what has been with the hadith and the verses in the Quran. Justice, or also known as adil, is literally means placing things in the right place where they belong. Allah does not forbid you from those who do not fight you because of religion and do not expel you from your homes, from being righteous towards them and acting justly towards them. Indeed, Allah loves those who act justly. The commandments and punishment is to provide or to uphold justice. Ibn Qayyim stated that Allah has sent scriptures and messengers to establish justice among people. Any path that leads to justice and fairness is an integral part of Islam and never contrary to it. The punishment in our act serves as a deterrent and as a means to provide justice. Islamic criminal law, which is one branch of Sharia, applies to all persons regardless of their status. It is based on the concept of equality in Sharia, as has been mentioned in Surah Al-Hujurat, verse 13. O people, we have created you, male and female, and have you nations and tribes, so that you may know one another. The noblest of you before Allah is the most righteous. This is also supported by a hadith that provides and that supports equality, which is no Arab has any superiority over non-Arab, no non-Arab has any superiority over an Arab, and no white one has any superiority over a black one, and no black one has any superiority over a white one, except on the basis of taqwa, which means that everyone is equal regardless of their skin color or their race. we have also included this element that Islamic law is applicable to all persons in our Act. As can be seen in the provision 10 in the general part, this Act is also applicable to persons outside of Malaysia, which means foreigner or immigrants. And this also means that the foreigners are not exempted from committing any acts that are contrary to what has been stated in this Protection From Harassment Act. Therefore, we firmly believe that we have incorporated the principles of Islamic criminal law, that it is applicable to all persons regardless of their status. We have applied the principle of equality as has been mentioned in Surah Al-Hujurat and also the hadith that I have read before. That's all from me. Thank you.
Hello and Assalamualaikum. My name is Ibtisam binti Othman and I will be presenting with Jurisprudence School that this provision, which are Section 6 and 7 of this Act, represents. Section 6, which is the offences in relation to the public servant or public service worker, represents the Jurisprudence School of Positivism, specifically Jeremy Bentham's principle of utility. This principle proposes that one man is worth just the same as another man, in which there is a guarantee in calculating the greatest happiness. Each person is account for happiness, and if that person is a part of community, then it is counted for the happiness of the said community. The virtue of utility is defined by the doctrine of utilitarianism. This means that the principle disapprove or approve an action based on its tendency to grant happiness. Under this principle, the main objective of criminal law is to increase the community's happiness. Punishment is made to only act as a deterrent in order to prevent general pain. Thus, it cannot be exaggerated. Applying this principle to Section 6, this principle ensures that a safer working environment is provided. A safer working environment will undoubtedly increase the happiness of a community as a whole. The punishment under Section 6 Clause 3, which is to be liable to a fine or 5,000 ringgit or imprisonment for not more than a year or both, serve as a reprimand towards the offender to prevent them from committing the same crime rather than a harsh and exaggerated punishment. Moving on to Section 7, which is unlawful stalking. This provision represents the sociological school, specifically the jurist Emil Durkheim theory on social solidarity. In short, this jurist views that the phenomenon of law as an index to the level of development within a community. According to this theory, collectivism is prevalent, whereas individualism is at low level in early and underdeveloped society, whereas in a more advanced society where collectivism is replaced with individualism due to widespread of labor division, it produces a more organic solidarity. When it comes to morality, it derives from what the society deems as moral. The law itself is a symbol for society's morality, which is why in criminal law, according to this theory, is defined as an act perceived as offending the collective conscience, which is a belief and sentiments common to an average citizens of the same society. An act is rendered as a crime because society's collective belief it so, which is to see an act that is so shocking and upsetting to them. The punishment under this theory is to satisfy the common consciousness rather than an act as a deterrent. Referring to Section 7, this very law existed to accommodate the satisfaction of society, as stalking is now seen as something immoral. According to a survey in 2008 conducted in Malaysia, it is found that 88% of the participants were stalked and 46% of them had their life disrupted because of that. In 2021, the Women Aid Organization and 50 other NGOs had called on the government to make an anti-stalking law in Malaysia. So it is obvious that stalking is an act that is deemed to be upsetting as well as angered by the society in Malaysia. The punishment itself, which is Section 7, Clause 6, which is liable to a fine not exceeding Rm10,000 or imprisonment for a term not exceeding 1 year or both, is rather satisfactory to society as the perpetrators are held accountable for such action, and a harsh punishment would surely satisfy the victims.
Assalamualaikum and good day, sir. A legal system according to HLA Hart. Sociological Legal Positivism, HLA Hart. Hart is known as a positivist. However, a more accurate title for him is a neo-positivist, a positivist who tends to the sociological approach. He acknowledged that moral consideration can influence the rule of law and is concerned with public acceptance of the rules. However, undeniable that his view is fidelity to law, which is the approach that a law remains valid without the element of morality and justice. Primary and secondary rules. According to Hart, a legal system combines two types of rules, namely primary rules and secondary rules. Primary rules include regulations that impose an obligation to do something or a prohibition on doing something, such as penal code. However, applying to our assignment, the primary rule is the Protection From Harassment Act, that is, the prohibition against harassment and stalking. Secondary rules are closely related to the primary rules and govern the primary rules. Here is the three types of secondary rules, which is first, rule of change, rule of recognition, and third one is rule of adjudication. Rule of change. The function of this rule is to amend the main rule to modify it according to the changes of the time. The other rule is to introduce new rules and regulations, to amend existing law and regulation, and to repeal old rule and regulation. Protection from Harassment Act. Stalking is not currently defined as a crime in Malaysia, meaning that if someone repeatedly calls you, follows you, and shows up in places you often visit the most command, and because of that it fears you, authorities couldn't do anything to protect you. According to the Women's Aid Organization, more than 1/3 of Malaysians have been stalked, in which causing them fear. These respondents were terrified after experiencing an act associated with stalking more than once or continuously by the same person. Almost half of Malaysians who experienced stalking-related acts reported a negative impact on their daily life. Nearly 1 over 5 of the respondents who experienced a stalking act said that they were unable to focus at work, did not feel safe being alone in public, and did not feel safe attending universities or a skill training course. The above statistics shows that the seriousness of the crime of stalking that should be addressed by the authority. In Malaysia, Parliament has the power to introduce and enforce new laws. Therefore, before the occurrence of the high-profile cases involving the crime of stalking, the Parliament has to introduce the Protection of Harassment Act, which covers the crime of stalking. Besides, Parliament also has the power to amend this Act depending on the changes in terms or circumstances. Now we move to rule of recognition. The function of this rule is to set conditions for determining the validity of a rule. In the modern system, the rule of recognition are more complex and can refer to sources of law such as the Constitution, court decision, legislation, and etc. In Malaysia, any decision given by a court or any act passed by Parliament is enforced as a law. Therefore, Parliament has the power to recognize stalking as a crime in Malaysia by introducing Stalking Act. However, it is pertinent for us to know that any act passed shall not be inconsistent with the federal constitution. Now we move to rule of adjudication. The rule of education include rules that identify an individual or body of law that has judicial power. For instance, rules that empower judge and police to determine that a person has committed a violation of the act and enforcement of the law. In the bill that we drafted, which is the Protection From Harassment Act, Section 11 of the Act authorizes the police to arrest without a warrant any person in their view that have been committed any offence under this Act, and that person shall be taken to the magistrate court to be dealt with according to the law. This demonstrates the power of the police to determine that there is a breach of provision by the person in their view. It also shows the power of magistrate court to deal with the cases in accordance with the law. In conclusion, Malaysia has met the criteria of the legal system according to HAT, which is the primary and secondary rules. Introducing the Protection of the Harassment Act shows the rule of change. Parliament passed a new law establishing the rule of recognition and the power of the police and court over offences under this Act shows the rule of education. That's all from me. Thank you.
Assalamualaikum warahmatullahi wabarakatuh. My name is Siti Khairina binti Kak Rusman and I will further explain on Protection from Harassment Act 2022 based on the lens of natural law school. The issue of sexual harassment is concerned with the natural law theories of ethics. The theory of natural law is immanent in nature, in which the enacted law must correspond as closely as possible, and this is supported by the maxim, an unjust law is not a true law. Firstly, Thomas Aquinas states that the light of reason is placed by nature, which is by God, in every man to guide him in his act. Therefore, human as one of God's creature use reason to lead their life, which is known as natural law. Secondly, he also states that good is to be done and evil avoided. Reasoning helps reveal natural law that are good for humans and enable humans to understand and restrain themselves from committing things that are evil, and it is unchangeable, such as murder and adultery. Thirdly, law is recognized as an ordinance of reason for the common good, made and enforced by a ruler or government. Hence, people shouldn't be bound to obey law made by humans that are conflicted with natural law. Aquinas states that law is categorized into 4 types, which are unified and interrelated to one another. The first type is lex aeterna or eternal law, or divine reason, known only to God. It is God's plan for the universe or his rational guidance of created things. All creatures must obey the law. However, man is endowed with free will and they can afford to disobey the law. Lex naturalis is the result of man's involvement in eternal law, and it can be discovered by reasoning, as well as it is the consequences of man's exercise their reasons and thoughts to have the basic principle, which is to do good and avoid evil. Lex divina or God's law is for mankind as revealed in the scriptures, which provide rules pertaining to the affairs of man's life. And lastly, lex humana is a man-made law, supported by reason and must in conformity with natural law, which is enacted for common good. Thomas Hobbes are of the view that natural laws of nature are divine law, that all humans are bound by them, and that it is easy to know at least the basics of natural law as the fundamental good is self-preservation, and that the laws of nature direct humans to this knowledge. Human as a rational being can comprehend that peace is good, and therefore also the way or means of peace are good. Hence, humans acknowledge the need to secure peace. Secondly, Hobbes also states that the practical imperative known as laws of nature is not to treat others the way we would not have them to treat us. These concepts of reason are eternal and immutable, as it forbids many immoralities such as iniquity and cruelty. Thirdly, Hobbes states that law directs people to obey the political authority and to seek peace with willing others by laying down our right to all things. This will result in a mutual covenant to be bound by the sovereign, whereby the government must effectively protect those who consented to obey it in order to determine political legitimacy. This is because rules of human conduct emanates from a supreme authority, which is some conception is God, and are binding on all men. In other words, The concept of sovereignty in relation to natural law is explained by Hobbes, which is covenant in obedience to the law of nature in order to secure peace and protection. According to J.M. Finis, he states that natural law is the result from a reflective awareness of what is self-evidently good for all human beings and from a practical understanding gained by experiencing one's own nature and personal inclinations. Secondly, he states that the objective knowledge of what is right is made possible by the existence of what he calls as a basic form of human development, which are objective goods, distinct from any moral evaluations of goodness. Natural law, according to him, is a set of principles of practical reasonableness to be utilized in the ordering of human life and human community in the process of creating optimum conditions for humans to achieve the objective goods. And thirdly, according to Finis, human rights must be maintained as the fundamental component of the human good. Such rights are subject to the limited of each other and by other aspects of the common good, where this aspect can be linked in issues concerning public morality, public health, or public order. Finis believes in some absolute human rights, for example, the right not to have a life taken directly as a means to further end. The concept on drafting the law on sexual harassment is based on natural law school is because law itself is backed by its notion and principles of intelligibility in action and the principle of right to life. The principle of intelligibility in action could only be carried out according to the idea that good is to be sought and bad avoided. Aquinas mentioned that there are a variety of things that count as good, which includes also reasonable conduct. Sexual harassment is against the principle of intelligibility in action, as humans by nature would have the objective knowledge of reasonable conduct that this offense infringes a person's right to life in the sense of honor and dignity of the victims are violated. The principle of right to life shows that sexual harassment clearly violated the natural law. This is because every human being has the right to live freely and safely without discriminating any other human being, as the right of a person is just the same as the right of anyone else. In the context of sexual harassment, the perpetrator has no right to deprive a person's honor and dignity. Therefore, the relevancy of Section 3, which prohibits the harassment, alarm, or distress to a person, is a human conscience and a reasoning of itself that the offense is wrong, as it infringes a person's right to life in the sense of the honor and dignity. The Federal Constitution constitutes life as a value that ought to be treated with the utmost respect. The case of Tan Teck Seng versus Suruhanjaya Perkhidmatan has interpreted that Article 5, Clause 1 of the Federal Constitution does not restrict the meaning of the word life only to the physical existence of a person, but also extend to the quality of one's life, which includes the dignity and honor of a person. In addition, the relevancy of drafting Section 9, which is a form of restraint ordered by the court, called as the protection order in this act, is a form of restraint for the offender and protection for the victims of sexual harassment. This order is made to protect the right to life of a human, where preservation of one's dignity and honor is crucial and in line with the natural law concept, which direct us towards the good, and that the good provide us reasons for us as rational beings to act and to pursue the good. That's all from me. Thank you.